Constitution Day 2008. I'm Janice Munsell, and I will be moderating this evening's program. The League of Women Voters of Billings thanks you for attending this evening's candidate forum for the Chief Justice of the Montana Supreme Court. Today marks the 221st anniversary of the signing of the U.S. Constitution. In this landmark election year, the League is working nationwide to highlight significance of our democratic process and reaching out to voters in an attempt to encourage a better common understanding of the Constitution and the rights it ensures us. For those of you who may be unfamiliar with the League of Women Voters, it is a nonpartisan political organization. It encourages informed and active participation in government. It works to increase the understanding of major public policy issues and influences public policy through education and advocacy. This afternoon, attorneys and professors discussed how a fair and independent judiciary safeguards democracy. This evening, we will hear from the two nonpartisan candidates for Chief Justice. The candidates will provide opening statements of up to 5 minutes. They will then have up to 3 minutes to answer several questions from our panelists. And then the candidates will also provide closing statements of up to 5 minutes. Our timer, would you raise your hand, please, will keep us on schedule. If time allows, I will also ask additional questions from the audience. On each of your chairs, there should be, or was at one time, a note card. And if you will write your questions on that, and League members will gather them. So if you have a question, write it and then hold it up a little bit, and one of our League members will pick it up and bring it up here. We would like to recognize our Constitution Day partners that are listed on your program. The League of Women Voters of the United States Education Fund, the Open Society Institute, the Yellowstone Area Bar Association, Parmley Billings Library, American Association of University Women of Billings, and United Steelworkers Local 11470. As soon as we relocate the sign-in sheets that disappeared from this afternoon's session, they will be located over on this table, and we would appreciate if you would sign in there. It helps our funders, makes them feel better. And there are also some additional independent judiciary materials over on the table. A little bit of housekeeping. Beverages and cookies are out that door, and the restrooms are out this door. Our first candidate tonight is Mike McGrath, who was raised in Butte, Montana. He earned a degree in business administration from the University of Montana and graduated from Gonzaga University Law School. He is an Air Force veteran. Mike provided legal services to low-income clients in Reno, Nevada, and he was the Lewis and Clark County Attorney before being elected Montana's Attorney General. Please join me in welcoming Mike McGrath.
Well, thanks, Janice, and thank you all for coming. I want to particularly thank the League of Women Voters for taking the lead in organizing this event and Constitution Day events in particular. I think it's important to a free society that we recognize the importance of our Constitution on days and with events like this, so it's much appreciated. I'm a candidate for Chief Justice of the U.S. Supreme Court because I think it provides...
That would be...
What did I say? That's good to know. Maybe that answers your question. Chief Justice of the Montana Supreme Court. Because it provides me with an opportunity to continue my career in public service in an area where I think I can make a contribution. I have as Janice said, served as the Lewis and Clark County Attorney for 18 years. Prior to that, I worked in the Attorney General's office for 6 and worked in the Legal Services office. And then I've served as the Montana Attorney General for the last 8 years. I think that we have accomplished a lot during that period of time. I'm interested in public service because I wanted to make my community and our state a better place to live. And I think I can continue to make a contribution by doing that. And I think I have the background and experience that would make me a fair, impartial, and a good Chief Justice of the Montana Supreme Court. There are a couple issues that I am particularly concerned about and think that we need to make some changes. First of all is delay. The Montana Supreme Court is a busy court. They handle a lot of cases, but the fact of the matter is they are seriously behind. They have a serious backlog. The Lee newspapers had a story earlier this year that indicated that 70 cases, over 70 cases were more than a year old. That's 20% of the pending cases. It's not at all unusual for cases to be 2 years old or 3 years old before a decision is rendered. I think that's a situation that's absolutely unacceptable. The Constitution itself provides that citizens are entitled to a speedy remedy, and when you have to wait a year, 2 years, 3 years, that's hardly a speedy remedy. People have personal lives at stake, business decisions are at stake, and there's just no reason to have to wait that long for that many cases. I understand that there can be circumstances where a case may take a long time, but not 20% of the caseload. So I think, given the administrative background and experience I have, we have 750 employees in the Department of Justice. Supreme Court has about 400 employees in the judicial branch. I think that I can introduce some efficiencies into the system and cut down that backlog significantly. The other thing that I would emphasize is an expansion of the drug court program. I've been involved with the drug issue and chemical dependency issues my entire career, and particularly lately with the Montana Meth Project. And I think it's an area where we've had an impact on meth use and the problems it creates in our communities. Drug courts are by far the single most effective thing that we can do to turn people's lives around, to keep them out of the criminal justice system, to give people their children back, to keep juveniles from getting involved in the criminal justice system. It takes some time and involvement from the judicial system, the judge, the county attorney, the defense attorney, probation officers, other people that are involved in the system. But it can make a significant difference. Those programs do work. They have a substantial number of those programs around the country that have proven to be effective. We don't have near enough of those programs in Montana, so I will be an advocate for the drug court system. Thank you very much.
Thank you, Mike. Our second candidate is Ron Waterman, who grew up in a small community in western Montana. He earned a bachelor's degree from the University of Montana and then graduated from the UM Law School. Before joining his current law firm in Helena, Ron was law clerk to U.S. Senior District Judge W.J. Jameson. He is admitted to the Montana State District Court, U.S. District Court, Montana Supreme Court, Ninth Circuit, and the U.S. Supreme Court. Please join me in welcoming Ron Waterman.
Again, thank you very much, both to the League and Janice, and also to all of you for attending this evening's debate. I think it's important, critical, I think, for individual citizens across the state of Montana to come to an understanding as to the two candidates who are running for Chief Justice, to see and contrast those two individuals and their skills and abilities and their background, because I think that that is probably how we are going to present ourselves as to which of the two candidates would make the next Chief Justice the best Chief Justice there. I am only running for the Chief Justice position of the Montana Supreme Court, and I have no other political aspirations beyond that, unlike some. My opponent has noted to me that it was suggested, and I've suggested many times, that it is clear, at least from my perspective, that this is the only position that I'm going to run for. I don't have any political aspirations to go beyond this in a partisan or any other position. The background that I think was introduced starts a 40-year career that spans probably all of the courts within the state of Montana and the Ninth Circuit. I have had the good fortune of being able to practice in a number of the judicial districts across the state. Before the Montana Supreme Court, I've taken approximately 100 cases on appeal to both the Montana Supreme Court and the Ninth Circuit. And I have represented individuals and Montanans across this state. I think that's one of the contrasts that there is between my opponent and I, is the depth and breadth of the experience that I bring to this office. And I think that that is an important distinction between the two of us as we seek to become the next Chief Justice. The likelihood is that that vast array of experience that I have will be called upon periodically and regularly as Chief Justice to adjudicate those matters. I believe I am the best lawyer to serve in this particular position. In addition to that, there are some administrative responsibilities that the Chief Justice has. And like my opponent, I agree that the concept of delay is one that has to be addressed. I would point out, I think, that what the Supreme Court has done so far is, in many respects, successfully addressed that to the point where that same delay that the newspapers pointed out in the spring of this year of over 70 is now well below 70, and the court is already moving in the direction of eliminating all of that delay within the next short while, probably within the next 18 months. I would do a couple of things to encourage and to accelerate that process. Number one, serve fully in all the capacities as Chief Justice to make sure that all 7 justices work full-time to adjudicate all of the cases that come before it. Number two, convene a panel to determine if we can accelerate the reduction of the delay as quick as possible and to eliminate the reoccurrence of the delay. In my 40 years of practice, I've seen the Supreme Court develop delay on 3 separate occasions. I think that we know that this may be a reoccurring problem, and I think that with a panel making recommendations, we should be able to avoid the reoccurrence of that. I point out 2 other points that distinguish me from my opponent. Number one, I am not a politician, and I do not have a partisan politician background as I come to the court. I believe that that's important for the court. Indeed, I think the fact that I haven't run for statewide office or office before tells me that that is an outstanding characteristic for a position that we want to be independent and nonpartisan. Finally, the distinction that I draw between myself and my opponent is that because of his current position, my opponent will have to disqualify himself from about half of the court's docket, at least initially. Ultimately, in 3 or 4 years, those cases will work through the system. But right now, as a named attorney, the Montana statutes require him to disqualify himself in about half of the docket. I don't think that that's helpful to the concept of delay, and I think that what the people of Montana want is a justice who can sit full-time to serve all of the people in all of the cases. Thank you very much again for coming. I look forward to the questions that will be given to us and to any comments from the audience.
Thank you, Ron. You may have noticed on the salmon-colored program this evening that under the candidates' names are given their websites, and you can garner a lot more information not only about their biographies, but their positions. Our panelists tonight are from your left. Jean Bender, attorney at Holland and Hart, law firm here in Billings. Robert Stevens from the Southside Law Center, again here in Billings. And Lorna Thackeray from the Billings Gazette. Thank you for coming tonight. Jean, would you like to start?
I would like each of the candidates to tell us how they perceive the job of the Chief Justice as being able to correct this delay problem, which all attorneys are well aware of. What exactly could you do as Chief Justice to solve that problem? I personally had a case that was up there for 3 years until very recently.
Who gets to start?
Go
Well,
ahead, Ron.
I think there are a number of things that you can do as the Chief Justice. One, of course, is work with your colleagues to make it a priority. You know, I think the court, now that I have been talking about this for well over a year, is certainly cognizant that this is a priority and that it will be if I become the Chief Justice. But I think there are a number of other things that you can do. The Ninth Circuit has a court commissioner, and the court commissioner under that system does a lot of the routine paperwork, the orders for extension, the kinds of mundane paperwork that tends to go through the court. Sometimes we get these court orders and all members of the court have signed a routine order that really doesn't need to be done. I would try to adopt a system and get the court to agree to designate somebody as the court commissioner to handle those kind of specific routine matters so that the court doesn't have to deal with that and the Chief Justice doesn't have to deal with that. I think we need more memorandum opinions. There are few cases that warrant an 80-page dissent and a 60-page opinion, frankly. And there are some, I'm sure, but not many. And I just think that most of the members of the court are brief, write succinctly, deal with the points of law that are raised in the particular case, and I think the court needs to focus on that. And again, that's a matter of leadership, working with your colleagues to persuade them to do that. If necessary, if a justice is behind, perhaps that justice misses the rotation until a justice gets caught up. So I think those are the things that I would do, at least initially, to address the problem.
Thank you. Ron?
The question of court delay is one that I think is confounded by any of a number of reasons. I think, first of all, we have to look at the root causes of why delay had occurred in the first instance. As I looked at that subject, it appeared to me as though for the last 10 years the legislature had ignored the court's requests for adequate personnel. Indeed, it wasn't until 2007 that each of the justices had a full staff and complement of individuals on staff to be able to accomplish that. In today's budget, there is actually a request for a couple of more clerks to be able to render matters in a more timely fashion. So I think a good deal of what's there and what needs to be in place is already there. With respect to the court commissioner, I'm not sure that I would agree with that, simply because at least it would take a statutory change, and it may well take a constitutional change to adopt a system somewhat like the federal system. And I don't think we either have the time nor should we spend the money to try and make those efforts to change that. Likewise, I believe that the court has already started to do shorter opinions, for the most part, in those areas where the court finds that the law is settled. As every lawyer knows, we have seen more and more the court noting that this is the matter on this is well settled law, and they have just simply affirmed the district court. And I would continue to urge that. And yet at the same time, there is a point where full opinions help both the bench and the bar. It's a matter of what the Supreme Court does. And one of the things that it does is it sets out for the public and for the bench and the bar an understanding as to how the court has reached its opinions on particular perspectives, so that lawyers can advise their clients as to what the court has done and where the law is moving, so that the bench can advise and rule on cases knowing not only what the court has said, but where the court is going, in hopes that they will then be affirmed on a more regular basis. So I wouldn't try and cut back on those few instances where lengthy opinions or dissents have been issued. In those cases, I think that they are warranted, and I would encourage everybody to get the work done, but I think that that would be the leadership that I would provide.
Thank you. Rob Stevens, would you take the next question, please? Or ask the next question, and and Mr. Waterman, would you reply first?
Certainly.
First of all, to the fairness of both of you, I want to do a little preamble. I am a criminal defense lawyer, sometimes referred to as an unindicted criminal lawyer. I also do civil plaintiffs' work, mainly representing individuals suing governmental subdivisions, political subdivisions, and corporations. Mike McGrath has a 30-year impressive history as a public servant, regretfully, from my point of view, as a prosecutor or the chief law enforcement officer of Montana. Ron Waterman has a distinguished career, checked in 76 Montana Supreme Court appeals. It appeared that most of the time, not all the time, but most of the time he appeared as a respondent for corporate and or insurance interests. Now, everybody has passions and prejudices. I want to ask both of you, what passions and prejudices will you bring to the bench, and what are your strengths and weaknesses in connection with dealing with those passions and prejudices?
I am in this race because of a passion for the promise of the Montana Constitution of justice for all. That has been the hallmark, I think, of the career that I have pursued the last 40 years. I am in this race because I care passionately about making sure that all individuals receive competent counsel at all levels of their experience with the justice system. I am in this race, I think, because I want to make sure that the promises of the Montana Constitution are fulfilled in people's lives on a regular basis through our court and the way in which it functions. What are my strengths and weaknesses along those lines? It is very, very difficult to examine oneself and say where the weaknesses are. But I probably understand myself well enough to know that the passion that I have has to be tempered with the reality and the realism of the moment. And that means that whenever I sit as a judge, regardless of the passion, I have an obligation to adjudicate that case on the basis of the facts and the law that are before it, and not to bring those biases, prejudices, or passions, however we want to call them, to bear to influence the outcome in a way that is distinct from what the facts and the law say, and distinct or different than what the Constitution requires.
Thank you.
I've always considered my career as a public attorney, particularly as Attorney General, as the attorney for all of the people, as having a higher obligation to the rule of law and to the Constitution. And I've always approached the work that I've done in that vein. So yes, I spent 18 years as a prosecutor. Certainly did a lot of civil cases in that time as well. But each of those cases requires an evaluation before it's filed. And I felt obligated to make sure that we had the facts that would support a charge in every case that I ever filed, and worked well with members of the defense bar in the 1st Judicial District for a number of years. There are often times that issues can be resolved, both civil and criminal, short of litigation. And I also know that from the years I spent in the courthouse, and we were able to resolve a lot of issues short of litigation by, I think, objectively evaluating the facts and the case before us, but also the situation that a particular defendant or a particular family or a particular victim found themselves in. So you look at my record, I think I have that reputation for fairness and impartiality. In terms of passion, I really addressed part of that already. The effectiveness of the drug court system really is remarkable. And I really will put some effort into encouraging all communities to adopt those, particularly in family court. Kids, we've got 50% of the kids taken from their homes and placed into foster care there because of their parents' drug abuse. The court can play a huge role in that system by reuniting these families, by going through the processes that exist in the drug court system. So they're very effective, and I am passionate about that.
Thank you. Lorna, would you please ask the next question? But I do have a request for the panelists to pick up the mic and use it to share that. Thank you. And so, Lorna, would you please direct your question initially to Mike, followed by Ron?
One of my passions is people. Oh, sorry.
Got a mic this on.
Maybe a little closer.
Hello?
Okay, I'm not used to speaking loud.
It's
She's getting some assistance.
It says the battery's dead.
Batteries not included?
They've just passed, is what.
I turned it on before we started, and it worked then.
Why don't you go ahead?
Technology break here.
One of the things that I have written a lot about and feel very strongly about is access to justice. And in all reality, if you don't have a lot of money, you don't have a lot of access to justice. And I know the State Bar and the Yellowstone County Bar have all worked at various programs to provide low-income or even middle-income people with access to justice. But what can you, as the Chief of the Supreme Court, do to improve on that?
Well, that's an excellent question. I started my career as a legal services attorney. I worked for legal services as a student and had a fellowship in a legal services office in Reno, Nevada. I spent 20 years as a board member of the Montana Legal Services Association. So this is an issue that I have been concerned about for a long period of time. I think there are a number of things that we can do. Part of it is making the system more open to individuals who have legal issues, legal questions, legal problems, and can't afford an attorney and maybe don't need an attorney. The court has made some progress in that area with a grant they had last, one-time only money they got last session for self-help law centers. And they've got some pilot projects in a couple of communities where people who have legal questions and legal issues can come to a courthouse and get a number of questions answered, can get forms, can do some things so that they can proceed in the system without the need for an attorney. I think that the legal judicial system itself needs to be cognizant of that. I've seen many judges who, because they're concerned about fairness or ex-parte communication and things like that, things they should be concerned about, go too far. They become too formal to the point where they won't even talk to a person, they won't give them simple answers, they won't address simple questions. I think that is an attitude that the Chief Justice can help address in terms of training, some revision to our judicial code of ethics in terms of how we approach issues like that. And then finally, I think we need to encourage attorneys in situations where people do need lawyers to do more pro bono work and to be more involved in
Thank you. Ron?
The issue of access to justice is one that I've addressed probably a good deal of my career. I've myself donated a great deal of time as a pro bono lawyer, and I continue even now during this period of time to serve as a pro bono attorney. But the access to justice issue is an overwhelming question that the courts are going to have to confront. Here in Yellowstone County, approximately 50% of all filings are done pro se, that is, by individuals themselves without lawyers. The same is true, actually it's a little bit higher in Bozeman, and the same is true in Lewis and Clark County. So we have an overwhelming number of individuals who simply can't find lawyers to address their issues. The State Bar has, or the Supreme Court has had some grant money, and they have put in place some forms and some training of individuals in each of the courthouses to make sure that individuals who come in and seek to file something pro se get assistance. But the truth of the matter is, the lawyers simply aren't doing enough, and I think the Chief Justice has to both lead by example, but also push by example, and encourage individuals to make certain that lawyers involve themselves on a pro bono basis more fully. Right now, the statistics are alarmingly dismal. Only 37% of the bar participate as pro bono lawyers, and the average number of hours a year that they participate in is under 40. It's about 42, actually. Our aspirational goals in the Code of Professional Ethics says that each lawyer should participate at least 50 hours a year with pro bono services. So for the State Bar as a whole, we're not doing very well. One of the jobs of the Chief Justice, I believe, is to advocate for justice. That means talking to lawyers specifically about how they need to become more involved. It also means going around and talking to the public about the access issues that are there. I went around this state all this summer on crutches and in a cast because I broke my left ankle. I've learned another issue of justice and access to justice, and that is in too many of our courthouses, in too many of our places where we hold out the opportunity for justice, people can't get through the door and up the stairs. And as a Chief Justice, I will take that memory of this summer with me forever, and I pledge that we will work to make sure that the promise of access to justice is not only the availability of lawyers, but the availability of removing barriers so that people can get to the justice they deserve.
Thank you. I'm going to ask a question from the audience. And Ron, if you take this first. Home foreclosures are rising. Credit card debt is at an all-time high. Article 8, Section, I'm not sure if it's 1 or 2, of the Montana Constitution requires the legislature to provide consumer protection and education. Does this provision provide any protection to consumers? If so, is it substantive or procedural?
The current economic woes of this country are going to be played out across this state. And we are going to have requirements, I think, both within the legislature initially and within the courts to respond and react to the crisis that I think is going to come to Montana as it has visited low and moderate means income individuals all across the United States. We do have that provision in the Montana Constitution. It certainly is going to be raised and advanced to the court as a question as to what relief can be afforded along those lines, but note, it is through the legislature. I think the courts have an obligation to make certain, as they are confronted with those issues, that they remember that they are one of 3 branches of government and that they are not a legislature, that they have an obligation to make sure that the legislature performs its legislative functions appropriately, but that they also do not transcend that and become a legislature themselves. Too often, I think, much of the criticism that we have that are directed at courts are for those judges who forget their roles, that they are judges adjudicating cases on the facts and the law that are presented to them. I do believe that the issue is going to come to the courts, as it will with the legislature, and I think the courts must respond accordingly, dependent upon what the facts are relative to our Constitution.
Thank you, Mike.
Well, we've made some progress in recent years in the area of consumer protections. That was an issue for me as Attorney General and continues to be. We have created an Office of Consumer Protection and Victim Services in my office. We have persuaded the legislature on numerous occasions to enact some consumer-friendly legislation. Sometimes we have failed. We had a bill last session to cap payday loans at the rate of 36%. We were singularly unsuccessful with that legislation. I hope that whoever my successor is as Attorney General picks that up again. It's an important piece of legislation. The U.S. military has a provision such as that. The Congress passed a cap on payday lending for members of the military and their dependents at 36%, and it's certainly something we should be doing in the state of Montana. There have been several cases that our office has brought that have come to the court in the area of consumer protection and antitrust. I venture to say that there'll be more of those. Some of you in this community are aware of some of the things that we've done in that area with, for example, charitable trust oversight that we did in the Bear Museum case. We have quite an excellent opinion that came out of the Montana Supreme Court on that, and it's being cited by courts all across the country in the area of charitable oversight. So there is some progress being made. People are now filing individual cases. Lawyers are filing cases, what we call key tam cases in the area of consumer protection. The court has allowed a broader filing of consumer protection cases by consumers. So I think we'll see more action in that arena in the next few years.
Very good, thank you. Jean, would you ask another question and direct it initially to Ron Waterman?
I'd be glad to. The subject of conflicts came up in your initial remarks. For the audience, conflicts are something that prevents a judge from hearing a case because he has had some kind of an interest in one of the parties prior to the case arising. Where would each of you, Ron, you've represented a lot of businesses, insurance companies. Mike, the state has been involved in many lawsuits. Where would each of you draw the line and recuse yourself from hearing cases involving either the state of Montana or prior clients of yours, Ron?
Well, certainly you start down the process in conflicts by going through and asking yourself whether or not the individual who is before you is a present or former client. I think you have an obligation to withdraw in all of those cases, and then by recusing yourself or disqualifying yourself, that's what I mean. I would likewise feel it appropriate to disqualify myself if members of my law firm were before the court. I think judges have to be very, very cautious about not only making certain that they identify the conflicts and withdraw in those areas, but also, because of the integrity of the system has to be protected, to withdraw in those instances where the public would perceive that there was a conflict, the appearance of a conflict. I think people have talked about this many times as you have to be Caesar's wife, if you will. That is overly cautious and overly protective to make sure that the institution of justice preserves the fundamental confidence of the people. And to do that, I think you have to say, is this an issue, or is this a client that I've represented? Is this a client that I previously had represented? Is my law firm involved? Or, for example, is this an issue that I've spoken so vigorously on or so frequently on that I can't be perceived to be without bias? Because those are the values that the public holds. We look to the courts, and we want the court to be unbiased. We want the court to be fair. And we also want to make certain, as judges, that that perception exists, because too often the perception of a conflict is then said to be the actual conflict. And what it does is it takes away the public's confidence in the law. As we erode away the public's support for the law, for the rule of law, we then destroy the most important of the institutions that's a cornerstone of our Constitution and our democracy.
Mike?
This is an issue that's a little bit unique for government attorneys in a government practice. And because of that, it is addressed in a unique way by the ABA model rules, which have specific provisions for government attorneys who then become members of the bench. Essentially, we went through this in a fairly detailed study when Brian Morris was elected to the Supreme Court. He had been in our office, he'd been a solicitor, state solicitor. And what we discovered is that the best way to handle this situation was that Brian needed to disqualify himself or recuse himself on cases that he was personally involved in. That's the provision in the model rules that the ABA handles, and that's how I would approach this issue in the future. The proposed rules of judicial conduct that the Montana Supreme Court has adopt the ABA model rules for government attorneys, and it certainly makes sense. I am not the named attorney on every case that is filed in the name of the state of Montana. For those of you who don't know, every criminal case is filed in the name of the state of Montana versus so-and-so. I'm not the named attorney in those cases and would have no obligation whatsoever to recuse myself unless it's a case that I've been personally involved in one way or another.
Thank you. Rob, would you ask the next question and directing it to Mike McGrath first?
Actually, I have a follow-up question for both of them. It's just a little bit different, but both are speaking on better access to justice. And Mike indicated that he wanted to have district court judges get more involved, and my suggestion or question is, doesn't that limit the impartiality or appearance of impartiality, and isn't that a court administrator job? And to follow up with Ron, you're indicating that there's 37% of lawyers reporting pro bono work of 40 hours. Don't you agree that's under-reporting? I accidentally do that in a month. Not intentionally, but I think lawyers do not report pro bono. And are you suggesting that a Chief Justice should have some sort of program to compel compulsory pro bono work from the bar? If you remember those questions.
And who do you...
I think, Mike, you were to be
Well,
first.
in terms of the question addressed to me, it's not just district judges I'm talking about. I'm talking about municipal courts, justices of the peace. And I'm not to suggest that you violate your requirement to be impartial, but I think that sometimes we look at that in such a formal way that people are intimidated by the system. They're overwhelmed by the system. And I think judges need to be cognizant of that. And I think there are a number of things that they can do in an individual situation. I've seen it happen in the courthouse constantly, where people go away, they have simple questions they want to get resolved. The judge could take care of those questions and help a person out without violating the requirement to be impartial. And many times these situations happen before a case is even filed, or can happen before a formal case is even filed, or before somebody's represented by counsel. So I just think we need to be cognizant of that sometimes it's our own system that drives people away.
Let me just follow up on that, just from my perspective. It seems to me as though the court has to, again, be very, very careful about not having the appearance of a bias. And so to the extent that the court is starting to give advice, even general advice, I don't think that that's an appropriate role for any judge. I do think, however, that there is a role to make certain that the court needs to make certain that the public has a way to obtain that information. I think it goes back again to these pro se forums and having trained officers in the courtroom and in the courthouse to help people find a way to have simple questions answered. With respect to the question about realistically, what do you do to increase pro bono? To the extent, I think you may be right. There may be some under-reporting. However, I think that the suggestion that we are under-reporting to such an extent that there is more than 37%, yes, there probably are more than 37% doing pro bono work. Yes, there may be more than 40 hours. I don't think that the Chief Justice should mandate that. But I do think that there is a key role that a Chief Justice can play, and that I think has a responsibility of playing, and that is to become an advocate for justice. That means to talk to the bar more openly about the needs to assure that that promise of justice for all means something other than just simply an empty promise. It also means, I think, going around and talking to individuals, making people more accessible. As I campaigned across this state, what really surprises me is how many times I've gone to individual courthouses and met individuals, introduced myself just as a candidate for Chief Justice, and been told that's the first time that anybody had ever met somebody even running for that position. And it seems to me, as a Chief Justice, you have an obligation to train, to teach, to make yourself accessible so that the justice system becomes a component, so that people have an understanding as to why this system of justice that we have is so critical and important in our everyday lives.
Thank you. Lorna, would you please ask the next question, and Ron answer first?
This is a question directly related to my industry and the public's right to know. The Montana Constitution is pretty clear on it, and the Montana Supreme Court has been pretty good about upholding that, except when it comes to lawyers. Recently, the Gazette lost a case before the Supreme Court to gain.
I'm sure the Gazette would never lose a case if either one of us.
Yes, that's right. Well, this concerns something a little bit deeper than that. The public's right to know was not, in our opinion, not weighed against the privacy involved in the settlement of that case against a city assistant city attorney. Do you have any? Yeah. Oh, well. Okay.
Yeah, Rob knows a little
Then
about
it's
that case.
your fault. But do you have any thoughts on that?
Well, I'm not going to comment on the specific case, although I'm familiar with it. And I've read the opinion because I wanted to see exactly what the court did. But let me answer the broader subject, because I think the broader question is the one that I think most people want to know. And that is, what about the public's right to know? In my practice, I've advocated for that right to know, and Mr. McGrath and I have been on the opposite side of some of those issues. But to make sure that the public enjoys what the Constitution promises. I've done that for the FOI hotline, the Freedom of Information hotline for newspapers and the like, to make sure that the public has that access. Because I see this issue, and I'm very proud of that aspect of our Constitution. I see this issue thusly, that if the public has an understanding of how government functions, it has confidence and the ability to have confidence in, therefore, the governmental functions. And so the more transparent government is, then the better and more confident that the people are in the operations and workings of their government. The more confident they have that they are being treated fairly, regardless of whether it's the executive branch, the legislative branch, or for that matter, the judicial branch. I think in all of those, transparency breeds confidence. So as a consequence, if I go and become the Chief Justice, I will take that experience and that attitude with me, because I think that it's been proven. Our Montana Supreme Court has very, very strictly enforced that promise of the people, that they will have transparency in the government's actions.
Thank you. Mike?
I think that the issue that often develops is the issue about the right to know and the public's right to know versus an individual's right to privacy. And in disciplinary cases, that is often the situation, certainly was in the particular case we're talking about. Part of it involves the interpretation of the Supreme Court's own rule. I think that the rule needs to be modified to the extent that I think there is a different situation where you have public employees who are accused of wrongdoing in their public role. I think that is a different issue in terms of right of privacy versus right to know. I think the public does have a more of a right to know in those situations, and I think that needs to be recognized by the court's rule and the way it's approached. I also think the court system itself does need to be a more open process than it has been historically. And I would strive, as the Chief Justice, to make it more open. I think we should publish an agenda in terms of what the conference is. I think we should publish the cases that the court is conferencing on and the dates they're conferencing. I think that we should publish the panel that's been assigned to a particular case once the panel is assigned. I think there are a number of things that we can do to make the system more open than it is, and that people can have even more reason to be confident in the judicial system.
Thank you. I have another question from the audience, and Mike, if you would answer this first. It's short and sweet. Should Montana have an intermediate court of appeals?
No. I can elaborate. I just think that that was addressed before. Under the current situation, the Montana Supreme Court takes every case that's appealed. You have a right to appeal civil, criminal case, and the court has to dispose of those cases. So it's long been discussed whether it would be appropriate to have what many states have is an intermediate court of appeals that would address selected issues, or you could confine it a number of different ways, and there was a bill a couple of sessions ago to do that. I opposed the bill at the time. I'm opposed to the concept now. I don't think we need to do that. I don't think we've demonstrated that we need to create another level of bureaucracy. I don't think we need to delay the process anymore, which is what I think an intermediate appellate court would do. Once again, we've got more formality instead of less. I think it's the wrong direction to go. I don't think it would solve the problem that we have. I think it would create a bigger problem.
Thank you. Ron?
I think that regardless of the merits of an intermediate court of appeals, we have to recognize the political reality that we have in the state today. Right now, we have 5 district court judges who don't have law clerks. We have 6 district court judges who don't have administrative assistants. We have a case study, a workload study, that says that we need an additional 15 judges at the district court level, and despite that, there is only a request in for 5 district court judges during this biennium. The reality is that the legislature has, for the longest time, been extremely reluctant to fully fund the judicial system at the level that is necessary for the judges at all levels to perform the task at hand. Long before we get to an appellate court, we have to make sure that each of our district court judges has the ability to do the work in a timely and proper fashion. That means a lot of work being done with the legislature to make certain, again, and I'll go back again to that same theme that I think I've talked to a lot, and that is concepts of justice for all mean justice without delay. That's what our Constitution promises. But that means that people have to, and I think the role of the Chief Justice is to advocate to the legislature to make certain that the legislature has an understanding as to the reasons why they have to fully fund and fully staff the district courts and the other courts to make certain that justice can be delivered.
Thank you, Ron. We will now have the closing statements by our candidates. Ron, would you begin first?
Well, again, thank you very much for this opportunity to sit down with interested citizens in Montana to talk about the justice system and who's going to become the next Chief Justice of the Supreme Court of Montana. That is the individual who's going to lead the judiciary, if you will, the head, the third branch of government for the next 8 years, for the next decade. And we in Montana are confronted, I think, over this next decade with a state of transformation. We are moving from a rural to a much more urban state. We have any of a number of problems that we are confronting, from the continual war of drugs that we see out in our streets and in our schools, to transformations of access issues, to transformations of both clean water and clean air. All of those issues ultimately are going to come to the court. And the question is, who of the two of us is best capable of leading that court? I submit that I am that candidate. And I submit that because I believe that it is the breadth of experience that brings value to an individual who can lead the court. I believe that it is somebody who has been an effective administrator in a law firm of the size that I'm a member of. I believe it is someone who has, quite frankly, a temperament that leads to consensus, which I think the court needs. I think it is someone who is committed to the proposition of what we talked about at the beginning and what we talk about all the time, what concepts of justice we all possess. When we say the Pledge of Allegiance to the flag, we end with that phrase, with liberty and justice for all. That cannot be as empty a promise as it has proven to be in this country. We need individuals who take that promise as a pledge to fulfill to all of the individuals. That means making sure that in each case, justice is administered in a fair and unbiased way without politics. That means that we have a court that is truly independent of the legislative and the executive functions, that is truly not invested with politics and partisan politics by reason of their association and long practice. That means that we achieve justice in this state. On November 4th, we are going to have an election of a number of individuals. One of those points to elect is who is going to be the next Chief Justice. I would appreciate your support and your vote on that day.
Thank you. Mike?
Well, I too want to thank you for being here tonight, and again, thank the League and others for putting this event together. One of the things that we didn't talk about was the importance of an independent judiciary. And I know that that was a topic of some discussion earlier today, and I think it's critical that the next Chief Justice be able to make the case to members of the public, to members of the legislature, about why it is so critical that we do have a judicial branch that is independent of the other branches of government. If you look at what happened just recently in Pakistan, where you had a president, Musharraf, who wanted to retain office, wanted to retain his powers. So what is the first thing he did? He arrested and jailed the members of the Supreme Court. Because he knows, and others know, that it is the court system that is what establishes the very rights that we have in this country. It's the very foundation of why we have a commercial system that is so successful. We have a way to resolve disputes through an independent judiciary. People believe in that. It's why our economy thrives. It's why we have a criminal justice system that strives to protect the innocent and convict guilty people through an independent process, and people have confidence in that. It really is the basis for the incredible society that we've built over the last 200 years, an independent judiciary that is not influenced by the will of the majority, but rather follows the Constitution and the rules that are provided through the Constitution of the state of Montana and through the United States. So I think it's critical that the Chief Justice make that case. Following 9/11, you heard a lot of conversation about we need to do away with civil liberties, we need to do away with this court system. I heard a member of Congress from this state on the radio the very next day talking about that very same thing. I've heard many members of the legislature talk about that. I think it's critical that the Chief Justice be able to make the case why we have an independent judiciary and why it's so important that we have a separate branch. Thank you.
Thank you, Mike. Before we close this evening, the League of Women Voters would like to thank the candidates, the panelists, Billings Clinic, which again has provided this marvelous venue, Billings Gazette for advanced coverage of today's programs, Community 7 Television, which will delay broadcast the program, and I believe Yellowstone Public Radio may stream the program online. But most of all, we thank all of you for attending this evening or via delayed broadcast. Remember to vote on November 4th or by absentee ballot. Good night.
Well, thanks much, Rob. Thank you. Thank you. Thanks for doing this. Nice to meet you.